All right, thank you. We have a quorum present. We may proceed. This afternoon, Council will consider the appointment of Majid Makhouf as the first Law Director of Cuyahoga County. I begin with an explanation of the process we will follow and summarize the charter provisions under which Council exercises its authority to hold these hearings. For each nominee, we have asked Mr. Fitzgerald to submit a written letter of nomination with the nominee's resume and documentation of the nominee's qualification as required by the Charter and the Ohio Revised Code. Once Mr. Fitzgerald submits his nomination, the 30-day time frame in which Council must act begins to run. Council received the nomination materials of Mr. Makhouf on March 22nd. The hearing will begin with, first, public comments for those who have signed in. Public comments are limited to 2 minutes. Mr. Makhouf will then address his qualifications, motivations for seeking the position, and outlook and plans regarding the office. Council members will then ask questions of the nominee. We will do so in rounds, allowing each member to ask 3 questions per round until Council's questions have been answered. Once questions have been asked and assuming Council is ready, we will entertain a motion to recommend that Council consent or not consent to the nomination at its next meeting. Assuming a motion to recommend consent or not consent has been made, Council will vote on that recommendation at its next meeting. The Director of Law is a Charter 5 office requiring appointment by the County Executive and nomination by Council. Under Section 5.06, the Law Director must be an attorney at law in good standing in the state of Ohio and shall have had at least 5 years' experience in advising or representing a political subdivision in Ohio. This is a new position under the Charter, and the Director of Law shall be the legal advisor and representative of the County Executive and County Council. Unique among the Charter offices, the Director of Law serves both the executive and legislative branch of Council. Thank you, and we will begin our proceedings. Are there any public comments?
Yes, Madam President, there are. Just a note that we have received a certificate from the Supreme Court of Ohio that Mr. Makhouf is indeed a registered and active attorney pursuant to the Supreme Court rules. First person who has signed in to speak is Kenneth Krause.
Mr. Krause?
Will I be seated or? I'm very pleased to be here to speak in favor of the nominee. I am here on my own account, although I have been recently elected as president of the Cuyahoga County Law Directors Association, and I'm in my 10th year as law director for the city of Strongsville, Ohio. In my view, there are 3 essential criteria that I would look for in a new Cuyahoga County law director. First, certainly a substantial record of experience and expertise in public law and municipal law. Secondly, a record of demonstrated ethics and the highest standards of integrity, and as reflected in that individual's reputation both professionally and also personally. And thirdly, the ability to communicate both verbally and in writing effectively, and most importantly, one who has the persistence and tenacity, if you will, to express his or her recommendations and opinions with respect to legal matters, both to this council and to the new county executive, so that his or her clients know where he stands, why, and hopefully that they will understand what they can and cannot do, what they should or should not do from a legal standpoint. I'm very pleased to report to you that, in my opinion, Majid Makhouf meets and or exceeds all of those criteria and my expectations for this position. I've worked with him in various litigation matters over the years. He's an excellent attorney. He's an excellent person both personally and professionally. I believe you're lucky to have him, and I would highly recommend him to this council as a nominee for appointment. Thank you.
The next person requesting to speak is Hema Steele.
Good afternoon, members of council. My name is Hema Steele, and I'm currently an attorney with the United States Department of Labor, but I am required to let you know that the views I'm going to express are those of my own and not of the federal government. Before I began working with the Department of Labor about 6 months ago, I had the pleasure of working closely with Majid Makhlouf at Taft, Stettinius, and Hollister. I was there for approximately 4 years. At the time when I arrived, I was a young attorney straight out of law school, and Majid was a senior associate who guided and supervised a number of the cases that I worked on while at the firm. And while I'm sure you are all aware of Majid's impressive and extensive resume, I'd just like to take a minute to tell you about what it was like to be supervised and guided by Majid as a young attorney. My experiences with Majid were extensive and varied. Through the whole time, he really shaped who I became as an attorney. Under his guidance, I conducted my very first deposition soon after law school. He also gave me the first opportunity to be involved in a trial that turned out to be a week-long trial here in the Cuyahoga County Common Pleas Court. And throughout that time, we were also working on countless motions to dismiss, motions for summary judgment, appellate briefs, and so on. And through that process, Majid taught me to draft, redraft, and perfect these motions, many of which resulted in successful outcomes for our clients. I have to say that Majid took on his role as a mentor, as an advisor, and a manager without having to be asked, despite having 2 young kids at home and having his plate full with a number of work and outside activities. I strongly believe that he is exceptionally qualified to head up his role as the law director. Regardless of the challenges that were put in front of him, he takes the time to thoroughly advise and supervise and guide his colleagues and less experienced colleagues. He's always considering his clients' objectives and goals and making sure that he's moving towards them. And most importantly, he gets positive results. So as a resident of the county, I would strongly hope that you confirm Mr. Makhlouf. Thank you.
The next person requesting to provide testimony is Stephen O'Brien.
Thank you very much, Madam Council President, members of council. My name is Steve O'Brien. I am the partner in charge of the Cleveland office of Taft, Stettinius, and Hollister, and also a member of our firm's executive committee. And I wholeheartedly endorse the comments both of Mr. Krause and Hema that preceded me as to Majid's qualifications. I, too, am speaking not only personally, but I think because of my position with the firm, I can also tell you that I'm speaking for our partners and the high esteem in which not only myself, but all of us firmly support the candidacy of Majid to become the first law director here in Cuyahoga County. Just a little bit about my background. I've been a public and municipal lawyer for over 4 decades. I have served for a long time as a law director of Independence and Bracknell, a short time in Solon. I am a past president of the Cuyahoga County Law Directors Association and the Ohio Municipal Attorneys Association. I've seen a lot of young lawyers who showed an interest in public law, none as outstanding as Majid. I think you know his qualifications. He graduated cum laude from Hiram. He started at Taft in '03, and almost immediately he knew more public law and zoning law than many young attorneys that I have ever encountered at his age. He became very early on a critical member of our public law group, representing many political subdivisions in this area, including Independence, Beechwood, Bracknell, Strongsville, Euclid, Worcester, Elyria, as well as the Cuyahoga Metropolitan Housing Authority, Cincinnati, and the Cleveland School Districts, and many others. I think you've heard the word tenacity. Majid is a wonderful person to have on your team advising and representing you. He's the type of person you'll want in that foxhole with you. He is tenacious, he is bright, and he's not afraid to tell you what he thinks is right and what is wrong. Most importantly, again, I don't want to reiterate, but and I guess that's a time limit for me. We attorneys sometimes have trouble in court and elsewhere adhering to these types of time limits.
We don't turn off your microphone.
I think the important thing that you know about it, he has been chosen by his peers as a super lawyer, and he has had all the accolades that could be expected. He was voted into our partnership in a class that was very small just this year, which is a high achievement and speaks volumes of his qualifications and his ability to take on this awesome responsibility. But what hasn't been mentioned, Majid is also committed to diversity. Our managing partner picked him to be a fellow on the Leadership Council of Legal Diversity, which is a nationally recognized position amongst all the large law firms in the country to support and enhance diversity in our legal profession. He is a co-chair of the Cleveland Metropolitan Bar Association Diversity Action Committee. He's on our firm's diversity committee, and I'm proud to say he was on the lead diversity center leadership group this year on behalf of the Diversity Center. So in sum, I guess I just want to say we feel in many, many ways this is an outstanding individual to become the first county law director. In many ways, our firm's loss, I think, will inure to the great benefit of this county. This is an individual who understands the public interest, his civic duty, and I wholeheartedly endorse his candidacy at this time. Thank you, and I'm sorry for going over.
Thank you, Mr. O'Brien. Do we have anyone else signed in?
We do, Madam President. Fred Livingstone.
Good afternoon.
Good afternoon, Mr. Livingston.
My name is Fred Livingstone. I'm a retired but still working partner at Taft Stettinius in Hollister. I've worked very closely with Majid on a number of cases that I've been the lead partner on. These are cases that have involved the federal government and federal contracts. And Majid has been my right arm. When I heard the news that he was being nominated for this position, I nearly cried. It was such a loss to me, but my loss, or our firm's loss, is the county's gain. Majid is a spectacular young lawyer. He's smart. He's thorough. He is innovative. He thinks on his feet. He's very good as a trial lawyer. And it's just to the council's credit that you're able to attract a person of this quality, particularly in an era when public service is so demeaned. And we're going to miss him terribly, but I want you to know that you're getting a hell of a lawyer. So I firmly support the appointment of Majid Makhlouf as law director of the county. Thank you.
Thank you, Mr. Livingston. Is that it?
That's it.
All right. Anyone else have public comments who did not sign in? All right. We've been joined by our county executive, Mr. Fitzgerald. Okay. All right. Mr. Makhlouf, if you would, approach the witness stand. Welcome, and we'd like to give you an opportunity to essentially give your opening statement.
Well, thank you very much. Madam President, members of council, thank you for the opportunity to be here, and I want to thank County Executive Ed Fitzgerald for sending my nomination to you today. And if I may add my congratulations to Council Member Greenspan for the birth of his child. Madam President, I was born in Jerusalem, and I grew up 6 miles north of the city of Jerusalem in the city of Ramallah on the West Bank. My father served as the Greek Orthodox priest of the city of Ramallah, and my mother worked at City Hall. My brother and I attended the Ramallah Friends Schools, which is a Quaker school on the West Bank that's been there since the late 1800s. In the early 1990s, Hiram College got a grant to recruit students from anywhere in the world but Western Europe. And a professor from Hiram College by the name of Denny Taylor traveled around the world, and he came to my high school in Ramallah. He told us about Hiram, and I was very much interested in attending the college. I didn't know, however, how my parents would react to me coming somewhere that they've never heard of. So I did what every teenager does under that circumstance. I knew when it comes to parents, sometimes seeking forgiveness is easier than seeking permission. So I secretly applied to the college and applied for a merit-based scholarship. I took the examinations, and I thankfully got the scholarship to attend Hiram College. I realized soon enough that my plan was not about to work because I needed to somehow get an airline ticket to get myself here, and I needed a travel document. So I confessed my misdeeds to my parents. They were very supportive, and they got me to Hiram. Hiram, in many ways, was the place where it all began for me, where that was my introduction to America. That was my introduction to Ohio, to Northeast Ohio. That's where, in many ways, I learned to speak English. I had studied English as a second language in the West Bank, and my written English was pretty good. Where I was struggled was with my spoken English. And what I did was I literally would make a list every day, would listen carefully to how other people would pronounce things. And Hiram being in the woods, I would literally go out in the woods and speak to myself out loud, and I would practice words: water, water, have been, have been. I always struggled with opportunity for some reason, that word I could never pronounce. And slowly but surely, my English skills came up, and I thankfully am able to have this position to be here before you and speak completely in English. In Hiram, I did 2 degrees in economics, in international economics and management, and in political science. And after Hiram, I went to the Ohio State University College of Law, now known as the Moritz College of Law, and did my law degree. And then, literally after graduating law school, it's a myriad of luck, if you wish, as I always happen to be at the right place at the right time. And over that period, I've had a number of people who invested in me in many ways, who put their reputation on the line and took the risk on me. They saw somebody with potential, and they were willing to throw me in the line of fire, thinking that I will come out okay on the other end. And I started with Rutzel and Andrus in Akron. And when I came in, I was hired into the business litigation group, actually, to do business litigation work and to do First Amendment, a lot of defamation work. And my very first matter was defending the Akron Beacon Journal and Knight Ridder over a defamation case. But soon enough, and I passed the bar exam November 2001, February 2002, one of the partners at Rutzel had a trial over a zoning matter in Copley Township. And he needed somebody to second chair the trial right away, and I was designated as the person to second chair the trial with him. And right away, I took the deposition of the expert witness on the other side, and even when we went to trial, I put on our experts, and I cross-examined the other side's expert. In this case, I learned everything that I had never even heard of before. I learned everything you want to learn about soil types, stability of soil types, JEDs, the Joint Economic Development Districts between townships and cities for the development of commercial and industrial sites. Had quite a bit of experience in just starting to learn public law in many ways. And I know that term is used all the time, and I'll use it here again, public law. Every law is a public law. I think when we say public law, we mean representing political subdivisions and more municipal law. We finished the trial. This was in February 2002. Soon thereafter, another partner in the Cleveland office had another major matter representing the city of Strongsville in the Cuyahoga County Court of Common Pleas. Contacts the partner in Akron, needed somebody to help him. The partner in Akron says, well, Majid just came up out of one trial. You might as well use him for your other trial. And I was shipped to the Cleveland office, and I ended up working on that other trial in September of 2002. So soon, within literally a year of passing the bar exam, I had second chaired 2 trials. Now, at that point, they were primarily zoning trials. I had done some other work representing, for instance, the Stark Area Regional Transit Authority in contract disputes down in Stark County. I had also briefly worked on a matter for Cuyahoga County, which was sued at the time by Applewood Centers over a breach of contract, and we represented the county in that piece of litigation at the time. From there, again, the fortune works its way. Taft had an associate in their public law group leave and join a federal judge, and they wanted to bring another lawyer into the office that had some public law experience, and a headhunter calls me in the Akron office, and I was interested and was able to come to Taft. And when I came at Taft, just to give you some idea of what we were dealing with, you literally had the law directors of Independence, Beechwood, Shaker Heights, Bracknell, Glen Willow, all at Taft. And I came in and I started working with all of them. And initially we had, literally within a few months of coming in, there was a major competitive bidding matter in Beechwood that I got involved in right away, and that ended up, it was injunctive relief, so everything needed to happen right away overnight. And we were involved in that and ended up having actually a trial on that. In addition to the cities that we had the law directors for, Taft was involved in representing the Cuyahoga Metropolitan Housing Authority, the Cleveland School District. So I, again, was involved in a lot of the matters for CMHA for the Cleveland schools. Also, because of the experience in public law matters, we would also often get retained by other municipalities when there would be a complex matter coming up. We've, in that capacity, have done work for Euclid, for Worcester, for Bay Village. And actually, with Mr. Livingstone, we would represent a consortium of school districts before the Ohio Board of Tax Appeals, filing amicus briefs over tax issues with the school boards when those issues arose. So, in terms of the areas that I've been able to touch on over the years in that experience, competitive bidding, zoning matters, contractual matters, insurance coverage of municipal corporations, employment matters. At one point, I even dealt with OPRS regulations. We were over the City of Independence engineer back from 1957 to 1967. The city had not paid PRS contributions for him, and we were dealing with that. Always representing a number of charter municipalities. Charters were always an issue, whether you can do things through ordinance or whether you needed to go out through the vote of the people in terms of how you could do things as a municipalities. These were issues that we're always dealing with. Eminent domain matters, federal contracts, regulatory issues. One of the things that we did with CMHA, for instance, is I reviewed their MBE program, basically their Section 3 program for compliance with federal regulations, and recommended a number of amendments to that. There was an investigation by HUD of CMHA with respect to the accessibility, the ADA and Section 504 compliance. We were involved in that. I literally was going in the CMHA properties and measuring the distance between different things, and the HEMA actually was involved in that. So we did that. Construction matters, both construction contracts and construction litigation, got involved quite a bit of that. Environmental issues, and even more recently with the sewer issues and stormwater issues, have had involvement with those. And often in representing political subdivisions, the questions of ethics and compliance with the Ohio Ethics Code, those were issues also that we've I've had to touch on. And doing all of this while also still doing business litigation. So I was doing all of this for municipalities and all the public law litigation, but I also was able to do quite a bit of litigation matters over mergers and acquisitions or breaches of contract between different bodies. So in many ways, it's been the diverse experience of a lifetime, having been there, and every issue that you can think of, we were able to touch on. Again, through luck, a friend by the name of Bruce Rinker, who is a lawyer at Mansur Gavin, was supposed to give a continuing legal education course for the National Business Institute and had a conflict come up and needed somebody to substitute for him right away. So he says, why don't you call Majid? He could step in right away and do the course for me. And that, I think, was maybe in 2004, 2005, I don't remember the exact date. Since then, I've taught over 20 continuing legal education courses on over 15 subjects, ranging from ethical considerations issues to access and road issues to abandonment and vacation of land to trial preparation litigation issues to resolving boundary disputes to annexation matters to land use matters to the right to take matters. So I've been able to teach a lot of those materials. Also through the firm, we always have a labor employment seminar every year, and I've also taught a number or spoke at a number of those seminars in terms of labor employment issues. More there it was in the private sector, but I've done that. And discovery matters. Also, again, you meet a lot of people and they remember you. The Real Estate Council of the Ohio State Bar Association, and it's the council, not the committee, which is something that you only get on through nomination and confirmation. I was recommended to join that, and I joined the Real Estate Council, and I attend their meetings in Columbus, and we follow a lot of the state regulatory process in terms of real estate, and sometimes recommend changes to the law, and even it comes into lending issues that we are involved in. I, as Steve mentioned, I've been fortunate to be involved in a lot of diversity initiatives. I started with the Minority Attorney Roundtable, where we created it with the Cleveland Metropolitan Bar Association. From there, I co-chaired the Diversity Networking Conference for the Bar Association. And then more recently, I became the co-chair of the Diversity Action Committee of the Bar Association. I've done a number of events with the Greater Cleveland Partnership with their Economic Inclusion Commission, and I spoke at their events on diversity matters in the legal profession. I've been to ABA conferences on the Minority Council of the ABA in Chicago, a number of those conferences, and more recently, I was nominated by our managing partner to represent the firm at the Leadership Council on Legal Diversity, and I was in New York for the conference there. Other activity that I've been doing is I've been a volunteer magistrate with the North Olmsted Youth Diversion Program since 2004, and this is something that I've been doing right all along. And more recently, I joined the Bay Village Planning Commission. So I sit on the Planning Commission in Bay Village. Let me turn for a second and talk to you more about the Department of Law and what I see happening for the department and in terms of how I see my role and how we can go from here. Obviously, we're in many ways starting a department from scratch. So we need to think of the fundamentals, and I've sort of made a list of the fundamentals that to think of. Number one, access to research and legal resources. We do not have contracts with Westlaw or Lexis or anything of that nature. What I did is the Cleveland Law Library, which is right across the street from the County Administration Building, I spoke with the chief administrator, and she confirmed to me that as county employees, you'd have free access to use the library, including their Westlaw and Lexis privileges. The Cleveland Law Library does have wide resources. I mean, I always say I'm like a kid in a candy store in that place because of the anything that you can think of, they have. And they also do services where they will email materials to you. And I've used them quite a bit sometimes when we're trying to get Attorney General opinions that are older, that are not on Westlaw, or sometimes you need some legislative history. And I've used the Cleveland Law Library. They're very professional, and they're very prompt and responsive, and they've gotten back to us repeatedly. So I anticipate that the department will use the Cleveland Law Library quite a bit. There is an issue in the sense that they're only open from 8:30 to 5 p.m. They're all open during the court hours. So if you ever need anything over the weekend, or if you ever need things after business hours, there is no way to access that information. The other avenue that's available is the Ohio State Bar Association has a database called Casemaker, which does have statutes and does have case law, but it's more recent information. It doesn't have any, especially when we're dealing with charter issues, and a lot of the times you need to go to some of the older law, which may not be available on Casemaker, but it's another resource that could be available to us. We do need resources in the law department in terms of materials in hardcover. I am one is treatises to some extent. Some treatises we're going to need to have there. You can't just keep going across the street to the library. You need for efficiency purposes. Two, I am a strong believer in technology to the point that my 6-year-old daughter literally goes to bed reading her bedtime story on a Nook, not an actual book. But even with that comfort level with technology, there are certain things in the legal profession that you need the hardcover book. The Ohio Revised Code. I mean, you're almost committing malpractice when you're doing that exclusively on the internet or on a database, because you need to be able to look at the entirety of the book, see that you're not missing a section that's preceding a section that's after. You need to put things in context. So I think something of that nature we're going to need the hardcover copies of them. We need reliable electronic research resources like Westlaw and Lexis, and that's where I hope we could have some cooperation with the prosecutor's office in terms of what they're using, and maybe joint efforts to be able to use Westlaw together. We need things that sound, very mundane, but they're necessary to establish the department. We need access to PACER, the federal court system, to be able to keep up to date in terms of cases, in terms of developments. A lot of the times, even when you're trying to cite a case, I often go back and try to get the pleadings on the case, because it puts the opinion in better perspective, and we need to have that ability to do that. So we need to find out what it would take to get that together and to get the account with the federal court system for PACER. Let me talk a little bit more even about the fundamentals of the law department, technology. And I very much believe in being able to do more with less, but to do that, technology can be a great help. At this point, there is no network system for the law department or a law department in the county. So we need to work with the IT department to make sure that there is a network system that anybody can, one lawyer is working on a document, another lawyer can access it, to have that ability to do that. And hopefully the IT department or whoever the appropriate body can help us with that. Two, what I care about even more actually, and then I feel strongly about that, having been at different firms and gone through different systems in terms of electronic filing of documents. And this is very essential for responsiveness to the client. You need, it's one thing to have the document on a network. It's quite a different thing how it's filed to be able to get it right away. And during my tenure, I've been through 3 different systems. One was called World Docs and Interwoven. And basically, most firms have that. I don't know what the prosecutor office has, but it can categorize things for you by subject matter, be it litigation, transactional, whatever the subject matter is, and then within that, you would have the specific matter number or the matter that you're working on. So whatever the matter is, you'll have the matter. And then within that, you'll have even categories: correspondence, research, depositions, whatever it may be. Even if it's a transactional matter, you can have a place where the contracts are, where the due diligence is, where so if somebody needs to find some element of due diligence on a contract, you immediately go in that matter, you go to the due diligence, and you're able to get, you have ready access to that information. Let me talk a little bit more in terms of the human capital that we're going to need for the law department. Obviously, we're going to need staff. At this point, we do not have any paralegals, and we do not have secretaries. And I think we have already two very able lawyers, but I think as we expand even more, and we have real need for their substantive work on legal matters, and we don't need them fighting with copy machines and performing some of the ministerial acts. So I think we're going to need definitely some staff, obviously limited, but we're going to need some staff to assist in the law department. In terms of attorneys, what do we need for attorneys? I sort of categorize those in two categories: the easy ones and the harder ones. The easy ones, and let me start with legislation and counsel needs. I think I've had the privilege to speak with some of the council members, and they've spoken to me loudly and clearly, and the message has been received and registered. I do realize the need for assistance with the council in terms of legislation, in terms of regular advice, in terms of also attending the council meetings and the committee meetings, and helping counsel. There are templates for, let me talk about legislation for a second, because my experience in drafting legislation is it's a two-tier process. There is the first part, which is the drafting of the ordinance. And there are templates out there that would have the whereas clauses, and you just fill in the blanks to some extent, and then you put in the more substantive. Often that job is not done by a lawyer. Often that job is done by a paralegal or a staff person to put the initial part of the ordinance or the resolution together. Where the lawyer comes in, of course, is in the review process, is in reviewing that ordinance or resolution, making any necessary revisions. And two, in providing some substantive advice. Do you need to have a grandfathering clause somewhere here? There may be an issue that you need to think about here or there. So clearly you need legal advice for that part of it. Now, I say that with a little bit of trepidation, because my experience has been in cities where our code is this big. And when you're doing, some drafting, somebody is doing, an amendment to some part or putting it, here we're doing everything from scratch. So I think we're going to need potentially, at least initially, having a lawyer involved in that process, and maybe as we're more comfortable with where we are, then you transition it, at least the initial part, to staff or paralegal, and then the lawyer doing more the substantive stuff. In terms of council meetings and committee meetings, and I know this has been an issue with respect even to committee meetings, the availability of staff. Quite frankly, I want to make sure that there's always somebody there, but in many ways, to the extent that I can be there myself, I want to be sure that I'm there myself for a number of reasons. Number one is I need to know what's happening and to be on top of everything in terms to be able to be responsive to counsel. But number two, sometimes being at those meetings can flag certain things, and you need flags going up in somebody's head right away. I'll give you a couple of examples. You've seen me attend some of the meetings here. I was here with the confirmation of Larry Benders for the Economic Development Commission, and as I was sitting here, he's talking about the needs, and one of the questions was in terms of how do we encourage exports. Now, to me, somebody sitting here, question immediately pops up in the head. Maybe it's not necessary, but that's a discussion that needs to be had with Larry Benders. Do you need help from the law department in terms of trade regulation? I mean, you don't think of trade regulation for a county law department, but if we're trying to increase exports, is this something that he needs some assistance in? So that's that's one example that popped up in my head just simply sitting here. I came and attended the presentation by Jeff Applebaum on the contracting and the multiple prime, and having done some construction work, one of the things that immediately popped into my head was something called the economic loss rule, which is the ability of the owner of the property or the developer to be able to get after the subs. And where, if you're often the owner and something goes wrong with the construction, one of your primary questions is how many insurance carriers can I go over, to make sure that there is full recovery. And there has been two. I've fought this issue in court before. There's been two decisions by the Ohio Supreme Court. One is called Floorcraft, and another one more recent decision called Corprex, which makes it very clear that the owner does not have privity with the subcontractor, and the only way you can go after a subcontractor is you have to sue the prime, and then the prime sues the sub. And obviously, if you have a contract and the prime goes, out of business or somehow, how do you go after the sub? How do you make sure now, I immediately went out. I spoke with Jeff about it, and obviously, his recommendation right away is that this is something that you need to make sure you're properly bonded when you do that. And I think in many ways that is council's decision. But as the law director, my job is to flag that, to say, hey, you just want to be careful in doing that. Think about how, if something goes wrong with the prime, how do you get to the sub, or do you need to get to the sub, or maybe in doing it, just make sure that you have the adequate bonding for the prime, so this way, the county is covered in what happens. So even if I'm not here myself personally, I want to make sure that whoever is here, those questions are popping up in their head right away. They're bringing it to my attention. We're bringing it to council's attention because in many ways, the answer to them are policy answers that need to be answered by council and through the legislation, but our job is to just flag those issues and alert the council to them. So that's with respect to legislation and council. The second easy one is, in many ways, labor and employment. And I break down labor and employment into two categories, basically. Number one is the collective bargaining. We are fortunate to have Ed Morales in the county, who has had substantial experience in collective bargaining on behalf of the county, and I understand even teaches some labor courses at Cleveland Marshall College of Law. So somebody who is very familiar and has been involved in every collective bargaining agreement that the county has had for the last number of years. I've talked to Mr. Morales briefly about this issue in terms of him being involved in introducing me to the players, and also as we go through the collective bargaining process, his assistance and in some respect leadership on the negotiation, and he was very willing to do that. So with his help and hopefully working together as a team, that's something that we hope to continue doing. Number two, and I sort of lump everything together there. Some of them, technically maybe labor versus employment, but I call them employment issues. And I'm, again, everything from discrimination issues to HRC to compensation issues to, and my understanding is there are 3 lawyers right now in the HR department. I have not had the ability to meet with them yet or gauge their interest to come over or to go over their qualifications and in terms of how they can help if they're willing to help. So that is a discussion. I think if we can internally, without having to add additional staff, with the staff that we have, bring people for purposes of employment, that is something I'm interested in doing and in interviewing them and see first of all, if they're even interested in moving over to the law department. 3, contracts. And I think, that is a broad topic, and you need, in many ways, different levels of expertise within contracts, because you're talking, from one aspect, the medical mart, to the purchasing department in terms of the purchase orders and what languages in the purchase orders. But we at least need some person with good familiarity and expertise in contract issues to be involved with us. And I'd like to some extent do an audit of all the forms that we have right now, or even develop contract forms for the county for when people are doing things that we have, those forms having been vetted by the law department and going through that. 4 is litigation, and obviously, that is a dispute with the prosecutor's office right now. But regardless of how that dispute is resolved, the law department needs to, at a bare minimum, monitor litigation, make sure that everything is happening properly, and for the performance of the law department's functions. That's something that is an elemental part of any law department, regardless of how that issue is resolved. 5 is the sheriff's office, and I understand that there is right now an in-house lawyer at the sheriff's office. I have not had an opportunity to meet with him yet, but that's somebody that I'll be meeting with and seeing what needs they do. I have had, quite frankly, some experience myself in defending the city of Warren in 1983 actions, claims of police brutality and things of that nature. So I've had some of that experience, and I think we've had some issues in Independence, not as extensive with that we've dealt with. The harder ones, the ones where it's not as easy for me to sit here and tell you we need X, Y, Z, because in many ways I need to have the interviews with the clients and really assess what their needs are. Some examples of that: environmental. I know the Transition Committee report recommended that environmental is one of the issues that you need lawyers on board with. That is too broad a category for me to understand really what that means. Just from my own experience with environmental law, I mean, I've dealt with issues relating to Superfund sites. You have VAP issues. You have, are we talking about brownfield remediation? Are we talking about sewer and stormwater issues? What needs, are we talking about litigation? What needs within environmental law are truly needed to be able to assess what we need for that department in terms of environmental law, and what expertise we need to bring on board? I think that needs, I need to have that discussion with the client, with the agencies that have that need, to fully understand what they need, and then come forth with recommendations as to how we can help them. The other one that I struggled with quite a bit, and it was in the Transition Committee reports, is bonding, because that is such a complex niche, and there is very few people that do that, and it's one of those things that it's too dangerous to do it and do something else. You almost, if you do bond, you do it quite a bit. There's a question on my mind when it comes to bonding. Do you do that in-house, or do you do that outside? Obviously, you need to monitor it in-house and make sure that everything is being done properly, but there's so much at stake that's not something that you could do part-time. That's something that you need somebody who is very much involved in it. I brought up another example, and I think maybe the answer to it is no, but in terms of trade issues, trade regulation, in terms of the thing that popped up in my head with Larry Benders. Children's Services, I think they have a full team of lawyers on their staff, but in terms of what they need, obviously other issues that come up in terms of the Health and Human Services, what needs do they have? The fiscal officer, what needs do they have? The medical examiner. We have the charter review issues coming up, and in terms of even redistricting coming up. And I think those, at least, I'd like to even be personally involved in. I don't know that it could be easily delegated to somebody else, but so those are all of these categories, I almost lump them up into the harder categories. I don't have immediate answers for you. I need to get in there and be able to interview people and see what their true needs are to be able to answer that question. And I'll rest with that, Madam President.
Thank you very much. Your statement was so comprehensive. I wonder if there will be any questions from the panel.
You answered a couple of mine.
I saw people checking out their questions. Mr. Gallagher.
Congratulations, Mr. McCloof, on your nomination. And as a young councilman, I had a problem in Strongsville, and you were a young lawyer. I don't know if you remember me. I somewhat remember you, and we had a very interesting, delicate, strange problem out there, and you were part of negotiating a resolve that was helpful to the city of Strongsville, and I greatly appreciate that. That was the Visconsi case that I saw. I don't know how you could say, oh. I still
my mind was on the Lewinsky piece, so that's why when he said resolve, I said, no, we just did the oral argument.
Oh, that was another one, but I still drive with my head down sometimes on the Visconsi thing. But if you are of the ilk that come from the Bowling Green State University, President Connolly would certainly be in your corner. I happen to be a father of a Hiram Terrier, and
my son went to Hiram.
And well, here you go. Well, there you go. I think we can leave now.
If I may add, Councilmember Gallagher, and I also do own a Cocker Spaniel, and who we got before my daughter was born. Sorry, go ahead.
Evidently, you are thorough. I don't really have a question, but I appreciate hearing your story. It was rather compelling. I've done my research on you and look forward to working with you in the future. And your Hiram story was very intriguing. The Hiram College didn't come knocking on our door for the ability to pick up a book. It was more to pick up a weight to play football. But in the end, I hope we have the education of my son and has the experience that you had. And certainly, if he could have half the career that you've had, we consider that a success. So welcome.
Thank you very much. I appreciate it a great deal.
Mr. Shrine.
Thank you, Madam President. Just to get down to some questions that would relate to background, do you have any clients that you've represented whereby you have been on the opposite side of the county and it's going to create any conflicts as you go forward at this moment in time, and any that we need to be aware of that maybe affect your ability to act as our law director?
Sure, and I've given that quite a bit of thought, actually, having taught ethics. And as you're aware, I'm governed by two sets of rules. One is the Ohio Ethics Code, and two is the Ohio Rules of Professional Conduct, and maybe soon the County Ethics Code. And this is something that's very common in the legal profession, and I've actually been through it myself. I started at Taft in 2003 when the firm had been in existence since the late 1800s, but had offices at the time in Cincinnati, I think Columbus, and Cleveland. And since then, the firm has grown into 8 offices, and every time you do a merger and acquisition, you have to deal with conflicts in terms of lawyers coming in and who you represent and who you do not represent. So here's what we have, is we have a very sophisticated, complete database of every matter that the firm has been involved in. And that database is comprehensive enough to have all the mergers in it. So whether it was Taft or any firm that merged with Taft is in that database. What I did is I ran a conflict check, and I ran it as broadly as Cuyahoga County and anything that comes up with Cuyahoga County to have a complete list of every matter that involved Cuyahoga County. To my chagrin, my partners in Cincinnati have a habit of putting the name of the court in the system somehow, so every time Cuyahoga County Court of Common Pleas. So I had to go through a number of those, and I vetted them item by item in terms of, I know the ones that I'm involved in, but I wanted to know entirely in terms of the firm's entire involvement. With respect to me, there is one item in which I am conflicted and clearly cannot do any work, which is with the City of Independence, there is an administrative appeal over Old Rockside Road, some financing issues, and there is an administrative appeal right now in court. I had been personally, involved in this matter briefly, not substantively, quite frankly, but have been involved in it to some extent that I would be conflicted from doing anything on it on the county side. What we plan to do, I hope to be able to do, is there is a term of art in the legal profession which is called a firewall. And basically, a memo would go out to everybody that could potentially have anything to do with that matter, and would say, you cannot talk to Majid or share any information with him or have any discussions or any documents with him with respect to that matter. So that is the one matter in which I have been personally involved that clearly there is a conflict. I am taking it one step further, and to the extent that my firm, even though I would not be conflicted personally, is involved in any matter against the county or any matter in which the county is on the other side. I've compiled a list of those matters, and actually primarily it's been matters before the Board of Revision or things of that nature. Quite frankly, I don't even know who those clients are. I've never met them. I don't know anything about them, but all I know is they showed up on the database, and I think my hope is to include them within the firewall to make sure that there's not even the appearance of impropriety when that happens. But they're all minor matters before the Board of Revision. They have not been anything of substance or that the law department would be readily involved in. I don't know if that answers your question, but
It does, because I was looking for specifically how many items are going to be outside the limits of the scope of where you were going to be able to work. And if it was a long list, I was hoping it was going to be a short list, which sounds like it is.
it is.
I'm conflicted because I'm limited to 3 questions, so I'll stay within that. The issue as far as when you talk about conflicts, one of the ones that we're wrestling with here will be the conflict if this body is desirous of an opinion that looks like it's going in one direction, and the county executive is desirous of a position that might be as different. How do you envision having 2 clients, having spent time in the military and having those same kind of issues come up? How do you envision having 2 different clients that might be going in 2 different directions on this very issue, and how do you resolve that conflict?
I think in many ways that happens all the time in any law department. And what the law director does is you shield yourself from it, and in the sense that for that purpose, you're not representing any client. You basically issue a ruling for the law. You study the issue and you issue a ruling on it, and that would be your ruling not on behalf of the executive or on behalf of it would be that would be what your ruling is for purposes of that matter. So that does happen quite a bit. Law directors often issue rulings. Now, I think where it becomes more complex is I don't know how often that would ever happen, but if you have counsel wanting to sue the executive, of course they are, you can't be. Yeah, but in terms of, but law directors always in any city, they're duty bound to issue opinions, and those opinions, even if, quite frankly, even the counsel and the executive may be both on board with something, and when you're issuing the opinion and you think that they can't do it, your opinion is to both. You can't do it, and this is in many ways the same whether they agree on it or not. When you're issuing opinions, you can't take what each side wants to do into consideration. That's not a factor that goes in your determination. And I hope that I would have the trust of both parties that they realize that this, in many ways, is the law director performing his or her duties, and they've done the best they can in answering that question without regard to which side thinks which way.
I'll leave the follow-on, which is I know is my colleague Sonny Simon is going to be asking about going to outside attorneys when we get to that conflict, I'm sure, at some point, or more than likely. But my third one is in regards to the county charter itself. How broad do you think that we can read this when we get down to the points of home rule and writing our own legislation that stretches the bounds beyond where it historically has been?
Sure. If I may sort of backtrack a second and sort of to explain this, to put it in context. When the county was a statutory entity, there is a rule called Dillon's Rule, which says that you strictly construe the powers of statutory creatures, of creatures of statutes. And they only have those powers that are expressly enumerated in the statutes or those that are necessary by implication to their implementation. There is no such a thing as implied powers of a creature of statute. When you go to a county system, when you go to a charter system, you flip that. So what it becomes is you have all the home rule powers unless they conflict with the Ohio Constitution. When it comes to counties, there is precedent that you have all the home rule powers of a municipality, with the one exception, which is when the county is acting as an instrumentality of the state. What do I mean by that? The duties, for instance, to record deeds. You cannot, by charter, come there and say, we're not going to, we're no longer going to record deeds. But outside of those parameters as to when the county is acting as the instrumentality of the state, the county would have all the home rule powers that any chartered municipality would have. And there are actually a number of Attorney General opinions specifically saying that exact statement that I just made.
So if we can go into Mr. Applebaum's presentation, then we can, in your early opinion at least, be able to stretch the bounds in reform on construction reform.
Here's what I want to avoid doing is having done this for a little bit, I don't want to render opinions on hypotheticals without studying them. And the number two, I think this may be something that would be very happy to discuss quite often, maybe within the confines of the attorney-client privilege, but not giving opinions on them without studying them enough to do that. But if you're given a specific fact pattern, the practice of law is a lot easier when you have a specific fact issue, and then you're researching the ability to do this specific thing instead of generalities. But that's something that we'll be very happy to study, and we'll have a lot of discussions about it, I'm sure.
Fair enough. I'm in sales.
Thank you.
Mr. Germana.
Thank you, Madam Chair. Mr. McLoof, what an impressive introduction. I've got just two areas I wanted to talk about, and probably not going to be that easy. One of them has to do with the diversity part. Okay, several occasions the diversity involvement with the law associations was brought up. Cuyahoga County is kind of diverse, and I think this county council wants to help to have inclusion. We want to have healing to Cuyahoga County. We want to bring people together, and we want cities to collaborate. Do you have any vision on bringing communities and the county together?
Let me answer it this way, and it may not be exactly the answering the question that you asked, because I want to avoid speaking as to policy in terms of, I'd rather stay to legal matters. But let me tell you in terms of how I think as to diversity within the law department and to diversity within the legal services for the county. And this is something I've given quite a bit of thought to, having been involved in it in the private sector before quite a bit, because there really are two different worlds. I mean, there is diversity everywhere, and there is diversity in corporate America, and there's diversity in government, and there is diversity in the legal profession. For whatever reason, diversity in the legal profession has been a very, very difficult thing to attain. Maybe it's the nature of firms, the comfort level between the partners and the associates, the work assignments. For whatever reason, diversity in the legal profession is very difficult to attain. And there are a lot of initiatives in terms of how to do it that many firms and governmental bodies are involved in. Here's how I look at it from two aspects. Number one is in terms of the department itself. I think we're starting, quite frankly, relatively well in terms of Mr. Morales there, Ms. Hurley, a female, and a Palestinian American there. So you're starting with a very diverse group of lawyers. A number of things that I would plan on doing. Number one is any times that there is a job posting, and this is exactly what Judge Oliver in Federal District Court does whenever there's an opening in federal court or a magistrate position. We send it to the Cleveland Metropolitan Bar Association, ask it to spread it to all the Diversity Action Committee and all the to let people know that there is a position open to apply for and to be interested in. So that's one issue, is access. How do we even let people know that we have these positions here and have them apply for it? Number two is, and pretty much every major law firm in town and every other governmental body, from the Ohio Attorney General's office to a number of the federal offices, participate in the minority clerkship program with the Cleveland Metropolitan Bar Association, which is a summer program that you're assigned a summer associate basically through that program that would help you to participate in that. And that's something I think when the time comes I'd like to get the permission to be able to do, to participate in the minority clerkship program. Number three, I have relationships with the individuals that are in charge of students in the diversity initiatives, both at Cleveland Marshall and at Case Western Law School. And in many ways, this is even a service to the local law schools, because if you provide their students with externships or opportunities to work part-time, one, it's a cost savings for the county in terms of being able to get services at a lower rate, but two, you're giving those students an opportunity to have something on their resume in terms of the experience that they gain working with the county. And three, you're giving the law schools an opportunity to advertise the access that their students have at that law school in terms of opportunities when they compete with other law schools and other jurisdictions in terms of working with us. So that's in terms of the law department, and in terms of to make sure that the advertisement, that everybody knows that there is a position and to be involved in those issues. In terms of the retention of outside counsel, and I learned this actually from Joanne Bober, who used to be the former general counsel of JCPenney at a conference. And she had a form that her staff would fill in. And the way she described it is, obviously if somebody's working in my department, they're the best and I trust them and I never question what they do. But I want to make sure that I remind them when they're making the decision that that's something to think about. And what she did is she had a form that every retention of outside counsel has to be filled out. Did you retain a minority attorney for that position? If yes, why? If no, why? Did you retain? If you didn't retain, did you retain a minority partner within a majority firm for that position? I don't know how I exactly feel about doing that, but I think I like the idea in terms of. I don't know that I would do that specific thing, but in terms of what I'd like to do is encourage firms that want to do work for the county to think about it. I can't force them to do anything, but I want them to think about it. So in terms of the RFP process, when somebody wants to do any legal services for the county, one of the questions on the RFP process would be on diversity, would be on statistics. less interested in how many minority partners they have than how many minority attorneys made it from associate to partner within that firm, because that tells me something about retention. That tells me something. There really is a very impressive group of young, diverse lawyers around Cleveland that have had a great opportunity to interact with. And I think you almost have to always remind the firms that this is something that's got to stay on their mind. I can't tell firms what to do, nor do I have the jurisdiction to do that. But what I can do is I can remind people in filling out the RFP process that this is something. Hey, somebody's looking over your statistics, in terms of what they can do. I didn't answer the question that you asked, but I hope I gave you an adequate answer.
Well, thank you. I think we as a new county organization, we want to break down some rules that are holding cities from working together. And, to survive, we're going to have to do that. So I think we in Cuyahoga County want to be creative in recommending to the state how these things need to be improved. But to skip that, from my point of view, it's almost like a cartoon. You have your conscience right over your right shoulder. I'm looking at the Inspector General, and she's been very intent on everything you've had to say. I'm just wondering, with this new concept of Inspector General with the county, how do you think the relationship's going to be and interaction?
I'm not really sure I fully understand the question.
Well, we've got a new Department of Inspector General. I don't think the county has had an Inspector General before, so we're starting from scratch. And I was just wondering if you had any opinion about how you would relate or be any involvement with the Inspector General situation.
Sure. And again, I want to avoid rendering any legal opinions on the record, so that's not what I'm doing. But here, let me give you the following answer. Is I think in large respect it'll depend on the ordinance that comes out defining the roles of the Inspector General and what powers the Inspector General has. Obviously, the charter does specifically give the executive the power to conduct investigations, and it could be through delegates. So I'm not as well studied and advised in terms of exactly what the Inspector General is doing now and under what authority, but I think that's something will be determined in terms of the ordinance that comes out of council when creating the departments and what powers that department will have. To the extent that and that will have to define in many ways the relationship between us and the Inspector General, because it's not unheard of. It happens, and actually we'll be even doing it here. You have a law department. I'll give you an example. The law department, representing and advising the Human Rights Commission, while also at the same time representing the county before the Human Rights Commission. I mean, that happens in cities all over the place, and it could be the position where if the Inspector General needs some assistance or something from the law department, that the law department could provide that. But I haven't studied that, and I don't want to give any opinion on the record on it until I've had an opportunity to look into it further.
Thank you.
Thank you very much, Madam President, and congratulations to you for your nomination, Mr. Marcouf. I have a question relating to the law department and its relationship to the prosecutor's office. Specifically, I'm referring to a memo I think you're familiar with, October 25th, 2010, from the prosecutor's office, rendering an opinion in conclusion as to the duty and responsibility of the prosecutor's office to continue its defense and representation of county boards, commissions, and expanded further to be the representative of the county council as well as the executive. And I think from hearing your opening statement and discussions with you that you may perhaps have a different opinion as to that role of the prosecutor and its relationship to the county council and the executive.
I do, and again, this is one of those areas where I don't want to say something on the record that later
Okay.
could be used. But I can give you those parameters in terms of, I think that's something, I've said on the record before, and in many ways, not a secret. The charter in section 5.06 expressly says that the law director is the, it doesn't say a, it says the legal advisor and representative of the county executive and county council. In section 13.06 of the charter, it expressly says that to the extent that there is any general law conflicting with the charter, that the charter provisions supersede any general law that may be conflicting with them. It is, and if you look to every appointed office, be it the medical examiner, be it the fiscal officer, be it the treasurer, be it the clerk of courts, the charter expressly says that the new position shall have all powers now existent or otherwise to be vested in their predecessor entity or in their predecessor officer. So I don't want to be rendering. I hope just the recitation of those parts is sufficient for you. But I think obviously my opinion is I'll just say one more thing is look to the Ohio Code of Professional Conduct, and I think there's been a question as to what represent means. As a lawyer in private practice, one of the very first things you do in an engagement letter, item 1 underlined, is scope of representation. The duty to defend and prosecute is a subcomponent of the representation. So if you look to the Ohio Code of Professional Conduct, it clearly repeats the term represent in connection with adjudicatory proceedings. If I know you had the Justice Committee look at the Ohio Code of Professional Conduct Rule 3.3, which deals with duty of candor to the tribunal. So clearly there's no question whatsoever we are dealing with the adjudicatory process. And if you look to subsection B there, it says when a lawyer represents a client in an adjudicatory proceeding. So I think you talk to any lawyer, when you stand up in court to do an oral argument, my name is XYZ and I represent, you don't stand up there and say, and I prosecute or I defend. So the term represent, I'll leave it at that.
I understand. I was focused as well as those definitions. Despite this relationship that we're going to be establishing in some form or other, do you see a way to share perhaps some resources with the prosecutor's office in terms of, maybe we don't know enough yet what the department's going to look like, our department, law department, but do you envision any sharing of resources with the civil division of the prosecutor's office?
I quite frankly would even like the council to order us to do that. I think the very purpose of the charter in many ways is to conserve resources and avoid duplicative services. And to the extent that we are doing anything that used to be historically done by the prosecutor's office, for one, we need the files, we need an audit of all the cases, we need an audit of all the contracts, we need that information. But number two, to the extent, the simple answer is Westlaw, but actually I'm even thinking in terms of human capital. If you have somebody there that's been dealing with the medical mart, and has that institutional experience having dealt with something of that nature, I want to have the trust with them. I want to be able to go back to them and deal with them and talk to them. And, I want somebody to educate me about the history where I wasn't there, what led to what. And I think in many ways, I hope that council, in creating the law department, orders us or our designees in many ways, to confer and provide for the orderly transfer and transition and reaching even agreements on the sharing of services, even employees if possible.
Okay, Thank you very much. And I just want to say I'm extremely impressed with your story, your qualifications, and I look forward, hopefully, to work with you. And I, too, served as a volunteer juvenile court magistrate. And one of the goals I have is to see council and the Justice Affairs Committee specifically perhaps seeing an expansion of that on a more regional basis. And I understand that's a purview of the jurisdiction of the court, but I want to really look at specifically the relationship between this new council and the courts and how those two systems can perhaps expand a regional approach to programs, and that specifically. So,
and let me be very clear that the law department, in many ways, would be at the disposal. Any questions of that nature, to the extent that the law department can help, or research issues, we are serving as the advisor and representative of council and the executive. So, absolutely, let us know, and to the extent that we can help, we'll be very.
Thank you.
Mr. Miller, then Mr. Brady, then Mr. Rogers. Mr. Greenspan.
Madam President, thank you very much, and I would also like to congratulate you on your recommendation for appointment, and I'm impressed with the thoroughness and logical manner in which you're approaching this position. My first question is except for the obvious question about the law director and the prosecutor, what other areas do you think there are where you think there's a significant risk that the new county government might be involved in litigation?
In terms of the charter issues, you mean, or in terms of just the county generally? I'm sure
Madam President, to Mr. McCloof, I'm talking mostly in terms of the power, scope, authority, and operations of the county government.
I'll run through in terms of the county as an entity, and obviously there's always litigation in terms of that the county would be involved in. I'll give you a very simple example. Now, I don't know that this is a crisis, but and I've cited that before. The Ohio Revised Code specifically provides that anytime you have a foreclosure action, you have to expressly name the treasurer and the auditor as a party to that litigation. Well, the treasurer and the auditor no longer exist, and that body is no longer what's called a sui juris body. That's no longer a suable body. It can't sue or be sued in court. So the proper defendant is the county executive in those pieces of litigation. So that's one thing. You're almost every single piece of literally every single foreclosure that's happening in Cuyahoga County, the county executive is a named party. So that would be one thing, and it's a material thing because really when the county comes in, it's over the taxation. So it's when, if the sheriff's sale does take place, it's the collection of revenue. So you need to be in that action to make sure that's something that's taken care of. There may be, I'm sure, as we have a new county government and experimenting with legislation and experimenting with creative ways to develop jobs, and there potentially could be challenges to some of the stuff that the council and the county would be doing. I mean, I'll give you one example that to the extent that we may be entering into contracts with corporations or entities, you could potentially have somebody coming in and saying that the county is getting into the aiding and abetting, of private corporation, of the limitations and article in the Ohio Constitution in terms of lending credit to a private corporation in terms of some of the economic development things that we may be doing. So that's why, in many ways, it needs to be vetted when it's done. But I think the powers are, there's a lot of powers, but there will always be somebody out there that will be challenging them, and you need to be ready to defend those actions. I don't know if I've answered the question that you were asking, actually, or.
You're in and around it. Thank you.
Thank you.
Madam President, to Mr. McCloof, what would be your middle case as opposed to best or worst case scenario as to how long it would take for it to be reasonably well defined from a legal standpoint as to what the things are that the county government acting under its new charter can legally do and what things it cannot legally do?
In many ways, those powers are defined. I mean, we are the second county to go into its charter powers. Summit County went before us, and there is a body of Attorney General opinions in terms of what Summit County could and could not do. So we always have something to go back to in terms of what happened in Summit County. I think the difference between us and Summit County is when it comes to the allocation of the officers and the powers that the officers can have, be it the prosecutor, they still have elected officers and things of that nature. But in terms of the powers of the county to enter legislation, to do contracting legislation, to do a lot of that stuff, there is a body of law out there that Summit County has generated in many ways that we can go back to often as a starting point, at least, in determining what we can do. Number two, we have even much longer a body of law for chartered municipalities. Because if we have all the powers of a chartered municipality, with the exception of when we are acting as an instrumentality of the state, then in those areas when we're not acting as an instrumentality of the states, we can look to what the cities have had the powers to do, and that, by way of example, gives us some guidance as to what we're doing. I have no doubt that there will be many challenges anytime you do something new. It's just part of the process that there will be challenges, that there will be questions. But in many ways, that's one area we're not starting completely from scratch, that we do have a very long precedent with chartered municipalities, and we do have some precedent with Summit County charter.
Madam President, final item, and this is given your appropriate reluctance to get into specifics. This is going to be more of a statement than a question, but it's to express interest and ask for your appropriate advice at the proper time as to whether the county government can pass any general laws affecting all its residents and impose any penalties if they're not complied with. For example, in terms of developing our ethics law, we're currently operating under the assumption that we can pass an ethics law that applies to all our employees and that applies to everyone that interacts with the county in terms of a lobbyist, and also that interacts with the county in terms of having a contract with us. But it does not extend to prohibiting what any individual person out on the street that doesn't have any of those forms of nexus with the county may or may not do. So I just express my interest. I think that question's going to come up in a lot of different contexts, and I look forward to your advice and guidance on that question. Thank you.
Thank you. And thank you, Mr. Miller. Mr. Brady?
Mr. McCloof, congratulations on your nomination.
Thank you.
I happened to have been in your hometown, didn't know it was your hometown until a little while ago, Vermala, quite a few years ago when I was probably about your age, and you must have been in high school, in the nearby Elbira, I believe?
Elbira.
You really are coming into a very fascinating position if you're confirmed. We all feel, I know, a lot of the weight slash stress of being part of trying to construct a new county government and trying to define what its role is, what our powers are. There was a lot of debate last year when we were candidates, all of us, the county executive, the county council, and about what kind of authority the council would have and what the limits of our authority was. How do you read the new charter? What do you mean? I'm encouraged to hear what I think you're saying is a robust sense of the county executive and the county government's authority under the new charter. Particularly interested in at least understanding as we move along what the potential is of the authority of this council, because there was a lot of discussion last year that tended to be more toward about what our limitations were going to be rather than what we could do, and I'm more interested in what we can do than what we can't do. There are a bunch of things in our basket as you come in here at the end of March that really beg for some discussion that we're really in the middle of. I'm not going to ask you to, and because by your presentation you anticipated so many of the questions, and by your answers to the questions that were raised, you were so extensive in your responses that you've really covered a lot of ground. But as Councilman Miller said, in terms of our ethics laws, in terms of the responsibilities of the IG, in terms of the relationship with the county prosecutor, in terms of how you balance off the relationship between the council and the county executive, and even in terms of the rules, we're passing legislation that is precedent-setting in many ways, and it could be that we may need to amend some of that as we go along and determine what the best way is to go forward. So I know that's not a question, but you really answered so many of the questions. I just want to say I hopefully look forward to working with you, and my question is, as the law director, if you were to be the law director of this new county government, the first law director of this new county government, if you could just be a little more expansive on how you see this role, and because it is a brand new role, you're stepping into shoes that have never been filled, at least these particular shoes, and how you see what is your vision of your role, the role of the law department, the role of the law director in the new county government.
Sure, Madam President and Councilmember Brady, thank you for that, and I didn't realize you've been through them all in LBR. I appreciate learning that. In many ways, the challenges of this position are what excites me about assuming that position, about the potential of taking on that challenge and taking it. I think as the law director, in terms of what I envision myself doing, is coming in, building a department. I am growing up in the Middle East, obsessed with the idea of institution building, because I've been somewhere where there haven't been institutions, and I've always been fascinated in many ways in dealing with the U.S. government in terms of the Solicitor General's office or the Attorney General's office. Is the machine of governments, keeps moving, and you change the people on top, and they come and go, but the process, the institution is there, is vibrant, and it keeps moving. So in many ways, that's what excites me about that position, is building a department that is functioning, and when I leave, whoever comes after me, they have something in there that's working very properly to serve the county and can move along. In terms of what I see my role, I think obviously there's the it's defined by the charter as to what the role of the law director is and what I'd like to do. But in many ways, I am somebody who just a lot of things get flagged in my head. As I gave you a couple examples, just sitting through some of the council meetings where things came up to my mind. So to the extent that any ideas that I have, I would share them with council. Any thoughts that I would have, I would share them with council and the executive. At the end of the day, the policy decision is not mine. The policy decision is the council's. The policy decision is the elected branch, not the technocrat. But to the extent that I can be of service to the departments, in many ways, to effectively serve your client, you have to know what your client's needs are. You have to understand what your client's business is. And in many ways, I need to delve in and understand what the county's business is. I mean, it's easy to hear there's the central services and there's this and there's the. You have to go in there and really see what each one of them does and how they do it and what they need and in terms of, from a legal perspective, what services you can provide to them and what they can have. And I think in many ways, if I've done that at the end of the day, if I've built a department that's functioning, that's operational, that 20 years down the road, my daughter can say, my daddy built that. And if I could provide any service that I could to the council and to the executive in doing that, any help, any ideas that I have, and responding to the requests of the inquiries and, in terms of providing advice or assistance, I think I would be happy with that.
Thank you, Madam.
Mr. Rogers.
Thank you, Madam President. Mr. McClue, good afternoon. And congratulations. And like most of my colleagues, I'm extremely impressed with your background and your accomplishments so far. I just have two questions. One, you touched on earlier your vision for the amount of, the staffing of the department. And you mentioned that there are a number of attorneys that are working currently in the county in various departments, serving in a capacity of providing legal advice to those departments, I would imagine, is what they're doing as attorneys. Would it be your preference to have those attorneys work directly for the law department, or have those attorneys continue in those positions and you work with them, or how do you see, if you can elaborate a little more on staffing?
Sure, and just for a point of clarity, I think in the sheriff's office, the person there is working in a legal capacity. I think the individuals in the HR department are not working as attorneys at this point, that they are providing more HR services, but they bring that type of expertise in that area of the law. So I haven't interviewed them to know what they... I think in many ways it has to be a hybrid process, but sort of centralized at the law department. And some of these things we have to make them as we go in terms of seeing what, I very much see the value to having somebody within a department that's responding day to day, but in many ways, the resources are going to be in the law department. The one other thing that I want to make sure that's never undervalued, and I always tell the story sometimes when you have clients that would pay for everything under the sun for a lawyer except for conferences between lawyers. And I've always been perplexed by it, because that's when the client gets the absolute most value. And this is how I want the law department to work, is I want the lawyers talking to each other. Have you run into this issue before? Have you what do you have to say about this? Getting each other's advice and sort of experiences. And I don't want to be in a position where I have an individual somewhere in some department and not having the value of raising issues with, walking down the hallway, talking that issue through with another lawyer, coming up with a combined solution. So I do start with the presumption that I want a centralized department with everybody in there, if anything, just for that. But as we go along, if there is a need for some, I understand, for instance, children's services, that is almost something in its own accord. But, if there is a need for counsel at that department, that's something that will have to be determined at that point. I think with respect to the HR people, we're very close. We're in the same building, I think even to some extent on the same floor. So that may not be as difficult a proposition as some of the more complex, in terms of other departments needing somebody somewhere.
And my second question, I was just wondering if you could elaborate a little bit on your experiences being a magistrate in the Youth Diversion Program at North Olmsted. How did you come to that position? How long have you been doing it? And what are some of the things that you've learned from that experience?
Sure. I started doing it. We had a partner in our Cleveland office by the name of Leslie Milton Jones, a good friend who was the magistrate in North Olmsted, and they needed another magistrate, and they were asking her for recommendations, and then she came to me if I was interested, and I talked to her about it. She's actually a labor employment lawyer who was also doing it, because in many ways, when you're practicing law and in a law firm setting, you're, day and night, it's a very intensive, laborious process that in many ways doing something on the side gives you an opportunity to do something different and contribute in different ways. So this is how I got the position, was through Leslie Jones that recommended me for it. I interviewed for it. This was, I think, in 2004. I've been doing it all along. Well, other than sort of all the precautions now that I have my own daughters growing up and being cautious about them, I think it's been the ability to help kids. And I mean it in every sense. You do see real results. I'll give you some examples, some of the orders that I put forth. I do have a rule. A lot of the times, especially, there are the easy case. I don't mean in easy cases, but sometimes the alcohol is the easy case. I hope the statement is not taken out of context. The harder cases are the truancies. And when you have somebody that is completely uninterested in school, and then you're having trouble with the parents, and you're having, I have a rule: you miss class, you make it up to me twice in community service, and I measure it by the minute with a minimum of 1 hour service. And you'd be surprised in terms of how quickly that gets the kid to the school in terms of them going back to school. And once they're in school, they start improving. I mean, the fact that they are in the class when the instruction is happening, you start seeing their grades come up a little bit, their self-esteem come up a little bit. There have been a number of success stories coming out of that program. My most challenging part of it is the truancies, but in many ways it's the place where I've had the most satisfaction and success, because I can't tell you, we do referrals for them to come back. After a couple of months, we keep monitoring them, so it's not a one-time thing that you see them and they're done. And when they come back and you just see the progression, it's incredible in many ways. So that's one thing. Drugs, we do the random drug testing, and you see in terms of, and I tell them in many ways I'm putting you on random drug testing because I'm giving you the ammunition out of trouble. This is your ticket when you're having peer pressure in terms of somebody coming to you and wants to do something. Hey, for all I know, tomorrow I could get the letter in the mail and it'd have to be tested, and anything within the last 3 weeks comes up. So you sell it to them as the ticket out of trouble, that you're giving them a tool to resist the peer pressure. And when you see how it works, and again, you see these kids again in a month or 2 months or 3 months down the road, it's very rewarding. I mean, you really feel you've touched somebody in some way. You've hopefully changed lives in many ways. So I believe in those programs because I've seen them work. I don't mean they work in every case. There have been, immeasurable cases where, you go through it and you try everything that you can and it doesn't work. But for everyone that works, it's worth it.
Great, thank you.
Mr. Greenspan?
Thank you, Madam President. I'm a little slower today on 3 hours sleep, but I am still here.
It gets worse.
To Mr. McCloof, I'm somewhat inquisitive and probably very challenging to folks who sit in the seat you sit in. But I must say, in the 54 words that outline the duties and qualifications of the law director, I think that I don't think I've been as satisfied and eager, not anxious, to have someone with your skills represent. At least I speak for myself on this council. I've worked with a lot of attorneys in my professional career. Some of them are overly aggressive when they go after interpretations of the law. I think your approach of being, I would consider to be cautiously aggressive as far as the interpretation of the charter as it relates to this overarching issue between the law director and the prosecutor is refreshing, and I hadn't looked at it the way you presented it, and I like your positioning, your stance. There's a question here, unrelated to that. I noticed that you are involved and my colleague discussed with your magistrate position. Are you going to be able to, or are you going to have to resign that position as well as the Planning Commission position in Bay Village in order to maintain an independence with the new job?
My hope, at least initially, is I do not see a conflict in keeping those positions. Obviously, if an issue comes up with Bay Village, then that is a more complex issue. With respect to the youth diversion program, my hope is to continue doing it, because in many ways you're doing a lot of good, and it's you're not dealing in any type of anybody before the county in any business capacity or any other type of capacity. It's literally school children who are there, and you're acting more not as an advocate for anybody or representing anybody. They're not your client. You're acting almost in a judging capacity. So I would very much like to keep that position. The Bay Village one is very much interested in keeping it, but I do realize that one could potentially raise an issue if there's ever an issue between Bay Village and. But again, I'm not on city council in Bay Village. I wouldn't be sitting. I'm sitting on the Planning Commission in terms of zoning issues in the city. So I realize the potential, and if there is ever, my test is not if there is a conflict. My test is if there is an appearance of impropriety. That's where I apply the brakes. So that's one I very much would like to continue it. But if ever any issues come up, I think that's when the decision would be made on it.
Okay, thank you. And just one further statement or comment regarding Councilmember Germana's statements regarding the IG and the interaction and what have you with the law director. I don't perceive, as we've written this legislation, obviously review of legal counsel is critical here, but since the duties of the director of law is to advise and represent counsel in the executive, and the IG's role is to investigate matters of violations of ethics laws in particular, I don't necessarily view there being a conflict, but I know that Inspector Byrd and I have been talking about developing the relationships between the various entities, such as the prosecutor and the sheriff's department and presumably the law director where applicable, to ensure that there is complete harmony between the various organizations. So although not a group, an organization that I thought of including in the mix, I think there's validity in including the law director in the mix of solidifying the various relationships. So that was just a general statement on the IG's relationship to the law director. And I have no further questions.
All right, anything further?
Madam President, to Mr. McCloof, two questions, or I don't know when I left out if this was asked. The Director of Law shall have at least 5 years' experience in the representing a political subdivision. Could you expound on that?
Sure. I have had experience, quite frankly, since at least 2002, even probably a little bit before that, in terms of representing political subdivisions. The one easy answer to that, obviously I can go through a list of all the political subdivisions that I've represented, but the one easy answer to that is the City of Independence. Because that one, if you go through my time records back to 2003, you can bet there's a couple of entries almost on a monthly basis, continuously through that entire time period. So so that alone, in terms of the qualifications, in terms of experience, because I've had the attorney-client relationship with Independence. But in addition to Independence, I've had the experience in representing the Cuyahoga Metropolitan Housing Authority. I've had the experience in representing the City of Bay Village. I've had the experience of representing the City of Worcester, the City of Strongsville, the Cleveland School District, the Metro Parks in one instance, actually more than one instance, and so it's been the S part in terms of the plural part. It's been multiple political subdivisions, but in terms of continuous, uninterrupted, at least the City of Independence itself, you'll add easily much more than 5 years on that.
Madam Chair, to Mr. McCoof, do you have any experience in the environmental law?
I do not call myself an environmental lawyer, but yes. One of the very first things I did actually as a summer associate even, when I was at Rutz and Andrews, they had a case involving the due diligence of a Superfund site, and was involved in that as a summer associate, doing a lot of the research on it and working on it. So that's how early it started. Over the years, and that's why I say it depends how you define environmental law. To some extent, when I did the Flats East Bank project, there were a lot of issues of brownfield remediation there. I mean, so you had a lot of the experience in terms of the CORF, the Clean Ohio relief funds, in terms of how those were obtained. So that's something that I've had to look into. I've had to research. The stormwater and then the sewer district cases, that's, to some extent governed by the EPA, a lot of that stuff. So there is environmental experience there. I'm trying to think of, it's been there. I'm sure there's quite a bit that I'm missing in answering your question. Yes, in even experience in representing private clients with Medina Solid Waste District and entering into their contract for the operation of the central processing facility for solid waste. So it's been, I would not sit here and call myself an environmental lawyer by any sense of the imagination, but I've surely touched on various areas of environmental law.
Mr. Schron, did you have another question? Oh, I'm sorry, Mr. Jones.
Thank you, Madam President. Again, Mr. McClure, congratulations on your appointment to this point.
Thank you.
You mentioned that in Summit County, the volume of opinions and legislation they have there. As we work on our ordinance, our ordinance for contracting and procurement, are there any things, any opinions, or again legislation from Summit, or just in your own experience, that could be helpful in our efforts to provide a lane for small business to operate and interact more closely with the county?
Let me answer it this way: is that it's obviously with respect to contracting and what's been done, that's something I would need to research. But there is clearly, when you're talking about the authority of council or the county to act, the contracting authority and for council to determine, that's one of the enumerated powers of council in the charter in terms of contracting and purchasing. Now, there is that entire body of law that I've addressed in terms of what can chartered counties do, which is basically anything that you can do under home rule powers, with the exception of when the county is acting as an instrumentality of the state. Again, I don't want to render any opinions on that, but when the county is contracting for services or for the construction of any project, or it's doing that for the county. It's not rendering any. So I'll leave it at that. But that's I don't want to be rendering any opinions on it. But I'd refer you to there's a specific provision in the charter with respect to the powers of council and also the Attorney General opinions as to the general powers of what a chartered county can do.
And I just have one more question. You've clearly stated that your position is that the law director represents the county as it states in the county charter. And I'm sure with your supporting laws or supporting evidence for that, do you see a working relationship with the prosecutor as you transition into what you see the role ultimately being? How do you see that relationship with the prosecutor? Do you see him sharing some of the workload with any type of understanding? What do you see your timetable for actually assuming what might ultimately be the position?
I would say not one, but both hands are held out to the prosecutor to work with us in this transition process, and in terms of specifically even the because it has to be an orderly transition process. It has to be, it's been a concern even in terms of, when you're assuming the law director's position, you can't start by abdicating your duties under the charter. And if you think your duties are to do X, Y, Z, you can't start by abdication. Yet at the same time, you can't do anything to harm the county's interest. I can go in and then the next day literally file a notice of substitution of counsel on every case in which the county, that I think is within my jurisdiction. What does that do with respect to the status of the case? Any depositions in the case, expert reports, any impending deadlines? That has to be worked out. There has to be an orderly transition with the prosecutor's office, even when you're talking contracting. I mean, Medical Mart is a big issue. The Convention Center is a big issue. They've been involved with that for some time, and we need to work with them on that transition process to make sure that transition process is smooth and works properly. So I mean it in every sense, not one hand. Both hands are extended out, and I'm willing to meet with him any moment, any time, and do anything that we can both do to serve the citizens of Cuyahoga County, avoid duplication of services, and provide taxpayer savings.
All right, thank you, Mr. Schrein.
Thank you, Madam President. Mr. McCloof, in regards to your vision for the department, have you put pen and pencil to you went through a whole litany of items you thought needed to be identified, everything from Westlaw to the facts that there's constraints using the Cleveland Law Library, and identified technology and databases, and then you went into staffing and law attorneys. At what point have you identified the cost involved with this, and have you actually identified those items that are additions and those items that are reapplication of existing costs?
I have not been able to do that process yet. I've been trying to do this in the middle still of a full-time practice, but no, and in large part, Madam President and Council Member Schrein, is I think we need to see how things work with the prosecutor's office, because they may have a lot of these resources that we already have, and I'd like to sort of work with them in terms of the sharing of how it needs to be done. But I need to investigate a lot of these issues further once, if I'm confirmed, to look into all of that. The idea is to come to council as soon as humanly possible with a budget in terms of what I think we need, and an educated budget, instead of, I can sit here and give you guesswork from my knowledge in terms of how much Westlaw costs for the firm, but that doesn't answer. I mean, there's a government rate for Westlaw. There's a lot of investigation that needs to happen, and to some extent, in many ways, some of this stuff needs to be delegated down, because you don't want, in terms of, there's only 24 hours in a day, and there's so much that the law director can himself or herself do. Some of more the administrative parts in terms of looking out, we may need some help on that in terms of other staff helping in terms of how we do that, in terms of the cost. In terms of hiring attorneys, I think that's, the pay range is something that would have to be determined, and it'll depend on the expertise and what we need for each position. So I don't mean to be avoiding the question, but I truly, is something that needs a lot more study once I'm in there to have an educated answer. I can sit here and guess, but it's not going to be.
I'd be shocked, having had a couple of conversations with you, that you don't have a back of the envelope someplace. But that's, just one other question in regards to the questions come up as far as when the time comes and we need to seek a second opinion, outside opinion. How and what techniques do you believe we have to go through in order to identify counsel and go out and seek that opinion? We've gotten one opinion from the prosecutor's office as to what the technique needs to be, and I don't know if you've been familiar with it, but I'd love to hear what your thoughts are as to how this body goes out and seeks that opinion.
Sure. One area of clarity that I want to make sure in terms of what my position on this is the charter says that the law director is the legal advisor and representative of the county council, and so there is no such a thing as concurrent jurisdiction between the law director and the prosecutor's office in terms of shopping for opinions, and one opinion you go to the prosecutor, another opinion you go to the law director. I think in terms of opinions, it goes directly to the law director as the officer charged with giving that opinion. So that's the starting step. Now, the second step is, let's say that for whatever reason, counsel wants to get another opinion. That is where, there are different ways to look at it. Number one is counsel's inherent powers. In many ways, that's a contracting issue. It's retaining consulting experts, and to do that, the counsel may have the inherent powers to do that. But even if counsel doesn't have the inherent powers to do that, if you look at the Ohio Revised Code, Section 305.14, there's two sections to it. There's Section A, which is when the prosecuting attorney, gets somebody to help them. But there's Section B, which allows historically the Board of Commissioners, but now you substitute the new entities for that, to obtain outside counsel on their own without going through the prosecutor's office. So that process is provided for in the revised code. There is a limitation on it as to the dollar amount under 309.09C. I think you can't exceed the compensation of the prosecuting attorney. Now, I think the question is, who is the prosecuting attorney now? Because there is, but at a minimum, it will be the compensation of one of us. So that's your almost starting. That's your almost starting point. So I think that process does exist. I don't think it's been vanquished.
Madam Chair.
Mr. Germana.
I feel privileged to make a motion to recommend to the full council Majid Maklouf to become the Director of Law.
Second.
All right. It's been moved by Mr. Germana and seconded by Mr. Schran. Is there any further discussion? Madam Clerk, will you call the roll?
Ms. Conley?
Yes.
Mr. Rogers?
Yes.
Ms. Simon?
Yes.
Mr. Greenspan?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Gallagher?
Yes.
Mr. Schran?
Yes.
Ms. Conwell?
Yes.
Mr. Jones?
Yes.
Motion carries.
Motion carries with unanimous vote. Congratulations.
Thank you very much.
Mr. Fitzgerald, do you want to make a statement before we close? We have to adjourn this section. Did you want us to make a statement? Yes.
No, look, you've seen what you're getting here. He's an extraordinarily qualified individual. His story is a great American success story, and I don't think we'd be hard pressed to find somebody that's got his combination of his breadth of experience and his enthusiasm for engaging in this new enterprise. It's a once-in-a-lifetime opportunity for all of us, and for Majid in particular. I really appreciate the council's patience in this matter as we were searching for the right person. I appreciate your deliberation and your confidence that you've expressed in him. I'll also tell you that we just in the run-up, he's shown a lot about what kind of law director he's going to be just in his run-up to all these proceedings, the way he prepared for this, the way he's already engaged with our staff. I thought it was noteworthy, talking about how he's mentored other lawyers before. I think he's going to be a great leader, as well as of his own department, as well as an advisor to all of us. So I hope you appreciate the kind of person we tried to bring, not just as my advisor, but also an advisor to the council. So you have my gratitude, and Majid's as well, I'm sure.
Thank you. This matter will be placed on the agenda for consideration for our meeting for April the 5th. Before we have a motion to adjourn, we indicate that we will have no further, we have no one else in the queue for confirmation hearings at this point. All of our confirmations are completed until we have any more nominations. We will conclude this meeting with our next meeting, which was supposed to start 5 minutes ago, for our work session. So is there a motion to adjourn?
Madam President,
yes.
I so